So here's a question for you. If art is done illegally, is it still protected by the law? That was the question legal experts in the US were posing as clothing company H&M launched a lawsuit against graffiti artist Revok. The company used Revok's work in one of their ads without permission, and after he tried to claim compensation, H&M sued him, saying he doesn't have any right to the work since graffiti is legally considered vandalism. H&M ended up dropping the suit after an online backlash, but the situation brought attention to the legal gray area surrounding graffiti protection. This morning, we're joined by Tara Parker, an entertainment lawyer at Goodman's LLP. Thank you for being here this morning.
Thanks for having me.
So, is it common for people to have the misconception, maybe like H&M did, that graffiti can be used since it was done illegally?
It's absolutely common. You hear it all of the time. If you ask your friends or ask people on the street what they think about this claim, some people might think it's some kind of money-grabbing artist out looking to make a buck where they shouldn't be entitled to profit from their illegal acts. So I think there is a lot of misconception about the intersection between copyright law and other kinds of law.
Speaking of copyright laws, how does Canada's copyright laws apply to graffiti?
Well, something that is considered an artistic work can be protected by copyright laws. In order to be considered an artistic work protected by copyright, it has to have two essential elements. One is that the work has to be original, and the other that it has to be in some kind of fixed, tangible form.
Right.
If graffiti can meet those two requirements, it could be protected under the copyright statute.
Fixed, tangible form, as in it needs to be put on something like a building or a structure.
Yeah, but even that is controversial because people could say if you paint over it or you can alter it or it's subject to the elements, it could be changed. And for that reason, some people could argue even that might not be sufficiently fixed to be capable of protection.
Tara, let's take a look at these two photos here. I want to show our viewers as well. On the left, we have a mural by the famous street artist Banksy. On the right, we have a spray-painted mailbox. So would those both be equally protected?
It's a really good question. If they can meet that criteria of originality and fixation, they could be capable of protection. That said, what you're seeing in the US and what you're seeing elsewhere is people saying, number one, they shouldn't be protected just from a matter of public policy. And if it's created illegally and it interferes with the property owner's right, why should they get to benefit from those rights? What's interesting is that the copyright statutes, both in Canada and the US, don't say anything about illegality. It doesn't say the work has to be put there in a legal manner. It just has to be original and it has to be fixed.
This is interesting because we know in many urban centers, graffiti's kind of a staple there, right? But people love to take their Instagram photos there. I mean, artists like to use that as a canvas for the work. So theoretically, could artists then say, if a city wanted to remove their work, that you can't do that because of copyright laws?
Absolutely, they could do that. And,
Wow.
and you'll see that actually happen in the US. There's this case called the 5 Points case. And there was a whole collective of artists, about 21 artists, that sued a property owner for painting over and then demolishing their work. They won that case. They won that case in the US. It's considered a landmark case. It's under the Visual Artists' Rights Act. But in that case, the court said that the graffiti did constitute a protected work, and they awarded the collective of artists about $6.75 million.
Wow.
Yeah.
That's a lot of money.
Yeah, it's a big deal.
So how likely then are graffiti artists to use copyright work to protect their work?
Well, it's a tricky question because you'll see a little bit of backlash, and there's actually a famous Banksy quote where he said, "Copyright is for losers." And I think the idea is that, sometimes art should be available to people to use in their own art to kind of modify and adjust and build new works of art. But when you see a commercial enterprise taking over that work and using it for their own commercial purposes and associating your art with their brand in a way that maybe you're not happy with, maybe that's when you step up and you assert your rights and say, look, maybe somebody on their Instagram filter can photograph my art, but I never expected H&M, who's had accusations of other things lately, including some other racist ads. Maybe I don't want to be associated with H&M. If The Weeknd has the right to end his relationship with H&M, maybe I, as a graffiti artist, also have a right to end my relationship and say, look, it's not just a money grab. I don't want to be associated with your commercial enterprise.
Do you think what happened here with H&M and Revok, do you think this might deter other artists, graffiti artists, to paint or put their work still on canvases around cities, or do you think that will stop them?
Oh, it's so weird because in the olden days, graffiti used to be detrimental to to a piece of property. It kind of defaces the property and may decrease its value. These days, you see graffiti enhancing the value of property. It's making some of these places destinations, and so in terms of enforcing your rights and whether that's a good or bad thing to do, it has to do with how people are looking at what you did in those circumstances. And I think everybody, both property artists and street artists, need to be aware of their rights.
Tara, thank you so much for those insights. It's really interesting, and we appreciate you being here this morning.
Pleasure.